duty from the date to the end of service advised to the date of judgment. E, 10% interest on the judgment sum from the date of judgment until the judgment debt is liquidated. Upon being served with the originating process commencing this suit, the defendant, with the leave of court granted on the 24th day of April 2018, filed memorandum of appearance and defense and accompanying the processes, filed statement of defense and its accompanying processes. The said motion notice was moved and granted on 24th day of April 2018. The claimant also, the leave of court granted on the 15th day of May 2018, filed and served his reply to the statement of defense. In proof of his claim, the claimant on the 15th day of May 2018 testified as CW1 and adopted his witness statement on oath. His evidence in this matter. The witness also tendered some documents which were admitted in evidence and marked as exhibit CW1A to CW1A. CW1A was cross-examined by counsel for the defendant thereafter he was discharged. The defendant on his part called one Emanuela Ioha, human resource manager of the defendant, who testified in the defense of the defendant as DW1. DW1, after a witness statement oath, adopted same as her evidence in this case. Documents were tendered in evidence and were admitted in evidence and marked as exhibit DW1A to DW1A through DW1 was cross-examined by counsel for the claimant thereafter she was discharged. The case of the claimant. I shall skip reading the reproduction of the case of the claimant. Counsel will have it when they collect the copy. Then the case of the defendant, all have been reproduced in the body of the judgment. The submissions of the defendant, the defendant formulated only one issue for determination, which is, has the claimant proved his case to be entitled to the relief sought? I have captured the argument of counsel, so I will skip reading the argument of counsel for the defendant in respect of the sole issue which was formulated. The defendants or the claimant's submissions, the claimants also formulated a sole issue for resolution, which was argued by C. Ikiocha Esquire. The argument has been captured in the body of the judgment, so I will skip reading the argument. Counsel will have the benefit of reading it when they collect the hard copy of the judgment. There is also a reply filed by the defendants to the argument there have been also reproduced in the body of the judgment. So I will not read it. I will go straight to the decision of the court. The decision of the court is as follows. I have carefully considered the pleadings, evidence laid by the parties, the oral submissions of counsel for the parties, and the final written addresses, which was filed, and the issues formulated therein. A resume of the gist of the case put forward before the court is that the claimant was initially employed by Money Bank in January 2000. It was employed by Money Bank as per Exhibit CW1A1 to 2 in January. In January 2006, the claimant was served with a letter notifying him of the merger of Money Bank with two other banks to form what is called Fidelity Bank PLC, which is the defendant. Claimant was by letter dated 24th day of March 2017 notified of employment with the defendant. However, the claimant pleaded with the defendant to rescind his decision on termination of his appointment and allowed him to resign from the employment. Consequently, by the letter dated 28th day of March 2017, Exhibit DWC, the claimant tendered his letter of resignation to take effect from the date of the letter, that is 28th day of March 2017. Following the receipt of the letter of resignation, the defendant by the Exhibit CW1C letter dated 8th day of May 2017 intimated the claim of his entire for the period of his service with the defendant. The claimant by letter dated 20th day of May 2017 contained in Exhibit CW1E 1 to 14 disputed the computation title as contained in Exhibit CW1 1 to 2. Consequently, the claimant requested that entitlement his retirement benefit, which was excluded from the computation of entitlement, should be computed and included in the end of service statement. When there was no response when there was no response to the complaint of the claimant instructed his lawyers to write to the defendant to demand for the computation of retirement benefit and gratuity and payment of sum within 14 days. The refusal of the defendant to pay the claimant as per letter of demand to the made by the claimant led the claimant act. The law is as the court Gabriel Atibi versus Kabel Matal reported in 2008 10 NWLR 1095, page 309, that a case is circumscribed by relief's claim, and the duty of the plaintiff, therefore, is to plead only such facts and materials as are necessary to extend the reliefs and adduce evidence to prove them. There are 6 reliefs being sought by the claimant. The first 3 reliefs, A, B, and C, are the main reliefs being sought from the court, while the other 3 reliefs are ancillary reliefs dependent on the grant of the main relief. Relief A is for the sum of 43 million naira 445,100 naira being claimant's retirement benefit, while relief B is for the sum of 4 million being the claimant's gratuity. There is also the claim of 400,000 naira being entitlement for spending 15 years with the defendant. These are the main claims of the claimants. These claims are monetary sums, are claimed for monetary sums, which are claimed for which a law as claim for special damages, which should be specifically pleaded and particularized is the case of company versus Augustus. as per Abba Aji JCA as she now JSC. In proof of special damages, the claimant is required to establish his entitlement to the sum and how he came by the custom of the sum he is claiming. See the case of Charles Ugele versus Access Bank PLC. To prove an entitlement, the employee must refer to the court to the extent provisions of the law or instrument or document that conferred the entitlement on him. See Otumba Gabriel Ladipo Abijo versus Promasido. And to prove the quantum of the sum claimed, the rule regarding proof of special damages must be adhered to. This is because the for entitlement and or benefit, as in the instant case, being monetary sums claim for special damages. See the case of Kelvin versus Fidelity Bank PLC. Here, the law is that evidence ought to be laid before an award for special damages is granted. And to succeed in a claim for special damages, it must be claimed specifically and proved strictly. The fact that it appears to be admitted does not relieve the party claiming it of the requirement of proof evidence. See the case of N versus Kilifo Nigeria Limited. See also Ignacio and others versus Aloysius Uzruama. All items of loss must be specified by the claimant before they may be a recovery granted. See Christopher Inwaji versus Costa Nigeria Limited. The defendant response is that the claimant entitled payment, as the claimant did not serve the defendant. The defendant also stated that the defendant has changed its policy and the defendant has stopped payment of gratuity, a retirement benefit, as far back as December 2015 and December 2016. It was also stated that the claimant has been paid his entitlement due to change of policies in December 2016. In attempt to prove his claim, the claimant tendered Exhibit CW1, Exhibit CW1, Exhibit CW1, C1 to 2, Exhibit CW1, Exhibit CW1E1, and Exhibit CW1A, CW1F, and Exhibit CW117. I have carefully perused the exhibits relied by the group of his claim. I have carefully perused the pleading and evidence parties before the court as exhibit tendered by the defendant in evidence. The claimant is relying on personal policies and procedure guide issued by the former managing director for his claim. However, the defendant tendered Exhibit DW1 as the personal policy and procedure guide as the document that replaced the personal policies and procedure guide issued by former managing director of the defendant, Mr. Reginald Ihiahi. It is clear to me that with DW181, the defendant is heavily relying. It depends. Is not applicable to the claimant in this case. The reason being that the said exhibit was made in 2017, few months after the services of the defendant. This was confirmed by DW1, the witness of the defendant, examination, where DW1 testified that with DW came into being after the service. Therefore, Exhibit DW1H1 having been made after the services of the defendant is not applicable to the case. This means that the DW1H cannot be used to determine the rights and obligations of the claimant and the period the claimant serves the defendant, despite pleading change of policies in paragraph 6 of the statement of defense, have adduced the purpose review policy of 2016. This means that no such policies exist in December 2016, and there was no such review on retirement gratuity. Or retirement and gratuity of the defendant. The defendant having pleaded that the said revised, having pleaded that having pleaded the revised policy is duty bound to produce it. The failure to produce means that the defendant has no such policy, or if it has that, then it is against it. That's why it did not produce it. The defense relied also on EW1G1 as evidence of communication to the claimant on the change of the policy. I have thoroughly examined with EW1G. There is nothing in it to indicate the employees of the defendant, including the claimant in this case, were notified of the said Exhibit D DW1 to 2. Since the claimant has denied ever being served with such treatment, the onus on the defendant to prove service on the claimant of the said document. However, the defendant has not used any evidence of service on the claimant of DWG. This means the claimant never notified of any change on policies on a retirement benefit. See the case of University of Ilorin and 3 others as Mrs. Aize Imokome Obayan, reported in 2018, 4391, or regarding the issue of service, onus on the defendant to prove service, which it has not done in this case. Exhibit DW2 also relied by to show that the claimant served for 9 months cannot assist the case of the defendant in proof of its defense. This because the document was prepared based on documents based on the document that were examined in the claimant's file with the defendant. In the claimant's file with the defendant, and the said claimant's file was never tendered before the court for inspection. To make matters worse, the officer that did the examination was never called as witness to testify in this case. In the circumstances, Exhibit DW1E1 to 2 has no evidential value. Same is hereby discountenanced for the purpose of this judgment. I shall now consider the case of the claimant. The parties in this case, by their pleading and evidence before the court, agreed that the claimant was initially employed by Money Bank PLC, see Exhibit CW 1 to 2. And in January 2006, the defendant in this case informed the claimant that there is merger between Money Bank to other banks, and now there is a merger between Money Bank and FSB to form what is called Bank PLC. Consequently, the claimant was retained as employee of the defendant, and he was reassigned another job schedule, see Exhibit C1B. However, by the letter dated 24th day of March 2017, Exhibit DWB, the defendant terminated the employment of the claimant. Claimant pleaded for rescinding of the termination of his appointment, to which the defendant acceded to. Thereafter, by the letter dated 28th day of March 2017, the claimant tendered his letter of resignation to take effect immediately. In response to the said letter of resignation, the defendant issued Exhibit DW1 to 2 end of service statement, which is the same with the CW1C1 to 2. By the letter dated 20th day of May 2017, the objected to the Exhibit CW1C1 to 2 due to omission of inclusion of his retirement benefit. By the Exhibit CW1F1, the claimant demanded payment of his retirement benefit from the defendant. The above summary of facts form the crux of the claimant's case. From Exhibit DWC, letter of resignation dated 28th day of March 2017, the claimant resigned his appointment with the defendant with immediate effect. It is tried to know that resignation of becomes effective and valid the moment it is received by the employer or representative or authorized of the employer. The reason being that there is absolute power to resign. There is no discretion invested in the employer to refuse to accept, and it is not necessary for persons to whom the notice of resignation is addressed to reply that the resignation is accepted. See the case of Yesu, governor of Edo State. See also the case of Adefemi versus Abungude. See also the case of Abayomi Adesumbo Adetoro versus Access Bank PLC. I reported deliver suit number NICNLA/293/2013, delivered 23rd day of February 2016. However, resignation with immediate effect has on repercussion. As it deprives the employee of claiming benefits which he may have been entitled to enjoy if his resignation was not with immediate effect. In the case at hand, no admissible conditions of service has been tendered in evidence. This means for an employee to properly resign his employment, he must give reasonable notice of his intention to resign. The case at hand, the claimant resigned with immediate effect. That is to say, without giving any notice. Without giving any notice of resignation or retirement. In the case of Wayek versus Oshinebo, it was held that a notice of resignation is effective not from the date of the letter or from the date of any purported acceptance, but from the date on which the letter was received by the employer or his agent, and that tendering of a letter of resignation by an employee carries with it the right to leave the service automatically without any benefit, subject to the employee paying any of his indebtedness to his employer, while giving notice of retirement carries with it right to be paid a pension and gratuity, but it does not confer the right to withdraw from the service immediately and automatically. See the case of Benson versus Onitri. See also the case of Yesifu versus Governor of Edo State Supra. The action of the claimant in resigning his employment with the defendant has deprived the claimant of his right to claim benefit from the defendant, apart from the salary. See Exhibit DWC, which is clear and unambiguous regarding the claimant's decision or intention, which was to resign his employment with immediate effect and not to retire from service of the defendant. This right position of the law has been restated by His Lordship, the Honorable President of the Court, in the case of Anokuro versus Omate benches, judgment of which was delivered on 16th day of March 2016. The claimant having resigned from the employment of the defendant with immediate effect had automatically left services of the defendant with effect from 23rd day of March 2017. The immediate resignation of the claimant also that the claimant has forfeited any benefit he may be entitled to apart from earned salaries, and there was no claim for earned salaries in this case. This means if it also means that if the claimant is indebted to the defendant, he must pay his indebtedness with his immediate resignation. The justification for having to allow the resigning employee to leave immediately is the fact that the employee thereby any benefit she entitled to, as well as the duty to pay off all indebtedness that he or she may have toward the employer. As such, the forfeiture of benefit inures as contractual compensation for the immediate and automatic separation of the contractual relationship as per the employment issue. So it cannot be that an employee who resigned his employment with immediate effect is allowed to also benefit from such immediate separation by the employer. As indicated earlier, the benefit which the claimant becomes disentitled as a result of the resignation with immediate the claimant is not entitled to or gratuity. Right to leave immediately, in the case of resignation does not extend to case of retirement. See the case of Waye, but Nobo Sufra, where held that giving of notice of retirement carries with it the right to be paid a pension or grant, but it does not confer on the right to withdraw from the service. From all I have been saying above, the claimant's resigning his employment, appointment immediate effect has deprived him of any cause of regarding any benefit from the defendant. With the above exposition of the law, this case is disposed of. However, since this court is court of first instance, I shall proceed to determine whether the evidence so far adduced by the claimant has established or proved entitlement to the claim to any of the relief sought. The reason being that if there is an appeal, the Court of Appeal will have the of knowing the position of the court. I have in the entire part of this decision refers to the court decision in Gabriel Atibi versus where the court held that a claim satisfied by them and that the main is to adduce evidence that will establish his claim, and the duty of the defendant is to adduce evidence that establishes defense. The main claim of the claimant is for payment of the payment of retirement benefit, gratuity, and entitlement for 15 years, which have been reproduced earlier in this part of, in the earlier part of this judgment. For the claimant to succeed in his claim for the
Philip. Philip.
Sorry, counsel. I have. Hello.
Yes, we are here, sir.
Sorry, please. The internet went off, but it's back. So I will continue from where I stopped. The claimant
as a court pleases
based his claim on personal policies and procedure guide issued by the former managing director of the defendant, Mr. Reginald Ihejahi, but failed to tender admissible version of the said document. This means the claimant has not adduced the requisite evidence to enable the court determine whether or not he is entitled to the sum being claimed. This means the claimant has failed to strictly prove his claim as required by the case of 7F Bottling Company PLC versus Augusto Sufra. In specific, holding that that proof of special damage is strict and must be established to the satisfaction of the court. I am not satisfied with the evidence adduced given the state of the claimant's pleading. Accordingly, I hold that the reliefs A, B, and C have not been proved due to lack of evidence.
You seen it? Huh? Philip, have you seen it? Print it and prepare an affidavit to show cause that the bank has no money in the bank, no account, no money.
Sorry, counsel.
The court pleases.
Sorry, the network is just problematic. In fact, I was reading the last paragraph, second to the last paragraph when the thing went off.
As a copy, please.
To be noted that the exhibit CW1E1 to 14 letter of demand by the defendant lawyer cannot serve as proof of claim. What the letter of demand can prove is that the claimant has made a demand for payment of what he is now claiming before the court. The letter of demand can only be proof of a demand and not proof of entitlement. On the whole, I find no merit in the claimant's case. It fails in its entirety and so is hereby dismissed. Judgment is entered accordingly. I make no order as to cost.
As the court pleases.
As the court pleases.
My Lord, on behalf of the claimant.
Yes.
On behalf of the claimant, my Lord, I want to appreciate the court for the well-considered judgment and the industry put into the judgment. We're grateful.
You're welcome.
May I, on behalf of the defendant, appreciate the industry and the extra effort put by my Lord to ensure that this judgment is delivered. We are most grateful, my Lord.
All right, you're welcome.
Thank you.
Thank you.
Have a nice day.
Thank you,
Thank you, my Lord.
Registrar for the next case.
Street number NICN/8BJ/335/2017 between Malam Baba Mohammed Abdul Karim versus Standard Alliance Insurance PLC. My Lord, parties are absent.
Appearance. Appearance. Yes. Appearance. Appearance. The network today. What is the problem? Appearance. Counsel, I can't hear you. Your network is cracking. Your network is not stable. Counsel, you have muted yourself. Unmute yourself. I can't hear you. Your network is not stable. It's not stable. Your network is not stable. Maybe you change your position. Counsel, I can't hear you. Your network. I can't hear you, Counsel. Check that file, whether I put that one small paper. Which I wrote an ID on it. Change to another system, whether yes. The network is still very poor. It's a small paper like this. Check, it should be there. Council, I can't hear you. Your network is not clear. I can't hear you. Your network is not clear. Where is hello? 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 Council? Where is Victoria? Let her come and call the council that I can't hear her.